Okay, the next case we have on the docket is Rex Bevins versus the State of Florida, case number 2023-3098. Is counsel for the appellant ready to proceed?
Yes, Your Honor.
Okay.
May I reserve 4 minutes for rebuttal?
4 minutes. Yes, ma'am. Okay, you may proceed.
Good morning, and may it please the court. I'm Michelle Yard, and I represent the appellant. I'd like to discussing the first ground in my brief and why it should be affirmed by this court because of 2 reasons. 1, I was counsel at the time of my motion to withdraw plea. But 2, even if I was not, there's still a per se reversible error due to the trial court's failure to appoint conflict-free counsel following its actual notice of conflict from the initial attorney before ruling on the motion to withdraw plea.
Counsel, and let me stop you with the ruling on the motion to withdraw plea. So there were multiple motions to withdraw plea filed in this case, right?
Yes.
Okay. So there was a motion filed by, I believe, Mr. Wilson, that may be his name, I can't remember off the top of my head. But right after that, 5 days later, there was a notice of appeal filed. And then you filed the second motion to withdraw. So, and then all of the events that you're talking about transpired. How did the trial court have jurisdiction to address anything beyond that first motion to withdraw?
In this case, the motion to withdraw allowed the trial court to maintain jurisdiction for purposes, or the motion to withdraw plea, to be clear, allowed the trial court to maintain jurisdiction for purposes of ruling on that motion. While it doesn't toll the appellate 30 days, it does allow the trial court to maintain jurisdiction until that is ruled upon.
Until that first motion? Right.
They were both timely filed. In my case, of course, it took longer because I had to request the audio, wait for the court reporter to provide the audio, and whatnot. So mine, of course, was filed on the 30th day. But in this case, as I've explained in the briefs, I was trying to wait for the other attorney to file the notice of appearance because it was my understanding that he could not be withdrawn under 3.111 and 9.140 until he had complied. I had asked him, the client had asked him, and I had asked him to file that notice of appeal much earlier, and he didn't do that. He filed.
The counsel, what about so 9.020? I would agree with that portion of your argument that says that first motion, that motion is acceptable, that tolls rendition, it was timely filed, so that notice of appeal didn't strip the trial court of jurisdiction. Okay. After a notice of appeal is filed, if you then file a motion to withdraw, the court does not have jurisdiction. The cases are legion saying that that motion to withdraw can't be ruled upon by the trial court unless there's some other action that's taken. So that's my concern. All of these events transpired after that notice of appeal, other than the first motion that is subject to that 9.020. So that's where I don't think that doesn't mean you have a free-for-all, from what I understand, to file whatever you want to file, and that doesn't affect the court's jurisdiction. So, and I think the Atkinson case from the first DCA especially speaks to this. It talks about pre and post filed motions to withdraw between when a notice of appeal is filed. So that's my concern, is where was the court's jurisdiction to do all of that?
Your Honor, 2 things. One is that even if a notice of appeal is filed before a judgment is rendered, it's essentially held in abeyance until the judgment is entered. In this case, I would argue that the motion to withdraw should be the same. But regardless, even if the court does not want to recognize my motion, there's still fatal error here that must be reversed. And that is because the initial attorney who filed the motion to withdraw the plea, it conceded before the court ruled on his motion to withdraw plea that there was an irreconcilable conflict. And that triggered, under the Florida Supreme Court precedent in Shepard, the requirement that before the trial court rule on the merits of that first motion to withdraw plea, that it conduct the inquiry on whether conflict-free counsel was required. Here, even if you never look at my motion, the trial court failed. It did not follow that Supreme Court dictate. It did not conduct that hearing. It did not allow conflict-free counsel. It did not appoint conflict-free counsel. It was notified directly that there was...
He filed his motion to withdraw, though, in response, saying that there was a conflict in response to your motion, correct?
But regardless, he notified...
Is that correct?
Yes, Your Honor.
Okay, and that was after the notice of appeal had been filed. I think that's what Judge Kilbane's getting at. That was after the notice of appeal was filed, correct?
The motion to withdraw as counsel?
Yeah, that came
Yes.
after, correct.
Your motion to withdraw plea, let's call it the second motion to withdraw plea, and I want to be careful because you have a motion to withdraw plea, you have counsel's motion to withdraw as counsel, so I want to be somewhat careful, and I think I want to build upon the question of my two colleagues. The purported conflict of original trial counsel was born because of the contents of your motion filed on behalf of the appellant, right? That's exactly what Judge Boatwright just asked.
That forced the attorney to concede that there was a conflict because of the allegations of the client against him.
Understood. And your motion, though timely, even if timely under the rules of procedure, was filed after the notice of appeal, was it not?
It was, Your Honor.
So would not 5th DCA precedent also dictate that the motion to withdraw plea filed after the notice of appeal and any court's consideration of that subsequently filed motion to withdraw plea would be a nullity because the notice of appeal had divested the trial court of jurisdiction? You agree with that?
I don't agree with that, but I don't think it's fatal to the argument here because the motion to withdraw plea was filed before the notice of appeal, and then...
The original motion to withdraw plea?
Yes, so not even talking about mine, right? There's the motion to withdraw plea, then approximately 5 days later, there's the notice of appeal, all from the original attorney, and then I believe 2 days later, the attorney moves to withdraw due to conflict. So for whatever reason, whether it was my motion or he spoke with the client, we don't know the reason, right? He says that he can no longer represent Mr. Bevins and that there is conflict and that he can have no involvement with Mr. Bevins, the appellant, whatsoever, is what he says. So the court then waited some almost 6 weeks to rule on that initial motion to withdraw. And it knew from 5 or 6 weeks prior to that that there was a Shepard issue, that the attorney who filed that motion to withdraw on which the court was going to rule had said, I can't be involved in this case. And that triggered the required hearing under Shepard. For whatever reason, if the attorney told the judge off the record that he had a conflict, it doesn't matter. Once the judge is on notice that there is irreconcilable conflict, an adversarial relationship between the attorney who filed the motion and has not, before he has ruled on the motion, that triggers, under the Sixth Amendment, a right to conflict-free counsel. And that didn't happen here. I mean, Mr. Bevins, the intention was clear, even ignoring my motion, that he intended to move to withdraw his plea.
But counsel, how do we ignore your motion if we're looking at Shepard, if we're saying that's where the defendant's motion to withdraw pursuant to 3.170 suggests a conflict between the defendant and counsel? That suggestion arose from a motion to withdraw a plea that was filed after the notice of appeal.
I mean, that's a presumption that the court's making. I mean, for all the court knows, the original attorney spoke with Mr. Bevan.
Well, that's what but isn't that what the motion to withdraw as counsel from Mr. Wilson, isn't that what, I can't make assumptions, I have a record. And most of that record has a jurisdiction issue, but if I'm looking at those things, all of that arose, it was alleged in the motion to withdraw a plea, okay, then the response, because that was filed by a different attorney, so not the one he's alleging to have the conflict with. So that's sort of the issue. Is there a Shepard issue that we can look at here?
There is. I mean, the facts of this case are no different than Shepard, right? Where in Shepard, there was a pro se motion, right? And the issue there was the individual was claiming that there was a conflict, and the judge didn't do anything, right? The motion to withdraw plea is a critical stage of the criminal proceeding. The person is entitled to effective conflict-free counsel under the Sixth Amendment. To find that the court, after having been notified by the attorney who filed the motion that there was an irreconcilable conflict, cannot somehow act on that would result in a violation of the Sixth Amendment. It results in Mr. Bevins not having a meaningful opportunity to be heard. It results in a violation of due process. The judge, Shepard, at a minimum, triggered the inquiry. At a minimum, Shepard says that if there is a suggestion of an adversarial relationship, the court must hold a limited hearing to determine whether that adversarial relationship requires the appointment of conflict-free counsel.
I don't know that anybody disputes Shepard. And let's say for purposes of the argument that your point's well taken in that regard. We still have to deal with the notice of appeal. That notice of appeal has jurisdictional consequence for the trial court. That's what I think we're trying to wrestle with, and we're trying to allow counsel an opportunity. And I still don't know precisely how a motion filed after the notice of appeal can be considered by the trial court on the merits, and the subsequent question or the related question would be if there is a conflict asserted by that subsequently filed motion to withdraw a plea, what is the impact of the notice of appeal on the jurisdiction of the trial court to consider the matter raised in the subsequent motion to withdraw a plea? That's where it's not what does Shepard require. It does not, should the trial court have held a hearing if both motions were filed prior to the notice of appeal? And I understand you had to wait on the record and all those sorts of things. Nobody's questioning your timing or sequence. But ultimately, if both motions were filed prior to the motion to withdraw a plea, then would Rule 9.020 consider the matter premature and allow the trial court to rule? I think that's one dynamic. But at least I'll speak for myself, what I'm trying to come to grips with is the effect of that notice of appeal on the trial court's jurisdiction as it pertains not only to the first motion to withdraw a plea, but the second motion to withdraw a plea and any relationship between the two motions to withdraw a plea.
I believe that once the motion to withdraw a plea was filed before the notice of appeal, that allowed the court to maintain jurisdiction exclusively for the purpose of the motion to withdraw the plea. The court in Thomas v. State, cited in the Appellate's brief, found that right after the 30 days have expired, that there was no jurisdiction to file a new motion. In that case, the attorney filed after the 30 days, under which 3.170L allows the motion to withdraw a plea. The attorney filed a motion to reconsider the ruling. And what the appellate court found was that the judge could only rule on the original motion, that the motion to reconsider, which was filed outside of the 30 days, was no longer jurisdictional. So I would maintain that for purposes of jurisdiction, the motion to withdraw plea, having been filed before the notice of appeal, allows the court jurisdiction to maintain the issues in ruling on that motion. I just don't agree that the notice of appeal divests the jurisdiction of the court for a motion that was timely filed before the notice of appeal.
So a later so would the first motion operate as a placeholder almost?
Yes, I mean, there, you know, in the rule, it says that 3.170L, that you have to file the motion within 30 days. It does not say before a notice of appeal. It doesn't say that in the rule. And I feel like if that was the operative fact, that the rule would include that. So I think presuming that the notice of appeal here divests the court of jurisdiction for the timely filed 3.170L motion is incorrect.
And I want to make sure, and I don't want to dance on the head of a pin unnecessarily, the motion to withdraw a plea that you filed on your client's behalf, that was not an amended motion, correct? You did not, that was not filed as an amended motion. You filed that as a motion.
Yes.
Okay.
Yes, the client retained me to file the motion to withdraw a plea because of the conflict with Wilson. So I was filing the motion that I was retained to file. I was not intending to come on as substitute counsel. I was coming on as additional counsel, which is why I filed the limited notice of appearance.
And I'm not taking issue with what you did. I'm just trying to make sure that I'm accurately recalling
Yes,
the nature
Judge.
of the file.
In Hicks, which was a 50 CA case, the court held, quote, that there is good reason to proclaim that a lawyer's premature actions taken in the best interest of the litigant have no legal effect. No good reason to proclaim that. Hicks also found that the restrictions on the rights to the access of the court should be construed to favor the constitutional right. And then in Shepard, the Supreme Court stated the general rule of striking pro se pleadings is designed to improve the administration of justice and not to frustrate it. I contend here that Mr. Bevins, the appellant, was denied any genuine opportunity to have his motion to withdraw, and talking about the initial one, considered fairly. He did not receive due process on that. The court cannot turn a blind eye. For whatever reason, if the court finds out there's a conflict, the court cannot turn a blind eye and ignore the Sixth Amendment and the dictates of effective conflict-free counsel. And there was a failure here, and that failure requires that there be a reversal at a minimum to hold that inquiry as to whether conflict-free counsel is required. In all of the cases cited in the briefs where conflict-free counsel was not appointed before a judge ruled on the merits of the motion, they were reversed and they were remanded for that inquiry to be completed. And that has to happen here.
Ma'am, you're into your rebuttal time.
Thank you, Judge.
Excuse me. Good morning. My name is Robert Bradford, and I represent the state of Florida in this matter. With respect to the first issue, I'd like to begin by talking about the two cases that appellant seems to rely on the most, Shepard and Hicks. Shepard was...
Let me ask you about that. Let's go ahead and start. Let me ask you didn't raise it in your answer brief. What about this jurisdictional issue? Did the trial court have jurisdiction to hear any of these motions after the notice of appeal was filed?
Your Honor, it did not. And the reason I say that is because the 5th DCA, this court has issued cases in the past which hold that untimely motions filed after a notice of appeal are not effective. There was the 4th DCA case, I think it was Adams, that held that if it was a timely motion that was post-judgment.
So you would agree the first motion was timely?
First motion was timely, yes, sir.
What about to her argument that once counsel stated that he had a conflict, that the judge had a requirement in dealing, he had not dealt with the first motion yet, that he should have held a Shepard inquiry at that point?
Well, and this is what I was getting ready to say about Shepard. The problem with that is that Shepard dealt with a case where a represented defendant filed a pro se motion. This was not a case where a second attorney tried to make an appearance. And as I argued in the brief under the general rules of general practice and judicial administration, there are specific ways that an attorney can appear on behalf of a client in the state of Florida.
But does that really matter once counsel says, hey, I have a conflict? I mean, does that really matter at that point who filed the motion, whether it was pro se or an attorney filed a motion that started that process
It
for him
does in the
to-
sense that Shepard, the holding in Shepard, the specific holding was that the represented defendant in his pro se motion did not need to make an unequivocal request to discharge the attorney. That was the specific holding. It reversed a line of cases that went back to, I believe it was the Logan case in the early 2000s, where the Supreme Court said, no, and because Florida jurisprudence for as long as I've been licensed has been that a represented defendant in a criminal action, if they file a pro se motion, it's a nullity. And so therefore, Logan said, well, so the defendant has to make an unequivocal request to discharge the attorney. But then Shepard kind of stepped back from that and said, well, no, this motion, it's pretty clear that that's what was created. It was an adversarial relationship. If you didn't use the magic words, I request to discharge my attorney, that's okay. That's all the holding of Shepard says.
Why does it matter whether he does that or another attorney does that on his behalf, though? That's what I'm asking. Why does that matter?
Again, because since going back, I think the case I cited in my brief was from 1939. Even before any rules, it's been the law in Florida that for another attorney to appear on behalf of a litigant, that they had to be substituted in if the person already had an attorney. There's only one way to make an appearance in the state of Florida. There's only one rule that governs appearances in the state of Florida, and there's the same rule governs.
Limited notice of appearance was not sufficient?
The notice of limited appearance in this case said that it was for limited purposes of post-conviction relief. Now, I understand this was after conviction, and I understand this was some sort of remedy, and so it was constituted relief. But in the criminal law parlance, post-conviction relief has a specific connotation, and it has a whole rule devoted to it, 3.850. And in fact, ultimately, that's what this case needs to go to. It needs to go to a 3850 hearing, a proper motion, and a proper hearing so that issues such as strategic considerations, whether there was evidentiary support, whether there was support in the law, whether Attorney Wilson had specific strategic, reasonable strategic intentions for how he presented this case at sentencing.
But once he notified the court, let's take out the jurisdictional issue. Once he notified the court that he had a conflict, you're saying the court doesn't have a requirement at that point to hold a Shepard hearing when the attorney says I have a conflict?
Well,
I mean, the attorney in this case,
the court
correct?
doesn't have a hearing in the sense that, well, in addition to the jurisdiction, this attorney, there was no proper appearance, there was no proper termination of the other appearance. So I think the court stated in a later motion, maybe the motion that denied the reconsideration motion, or the order denying the reconsideration
When
motion.
counsel's motion to withdraw, he says, I have a conflict, right? Correct.
Created by the second motion to withdraw the plea, yes, which was unsworn, unverified, and unsupported by an affidavit. So they're allegations, but again, we have no evidence. In a 3850, it has to be either sworn motion, there has to be that statement under penalties of losing my privileges in the Department of Corrections, et cetera, et cetera. None of that's here. We don't have that. The court specifically felt that from the time that Attorney Wilson was allowed to withdraw until Attorney Yard filed her second notice of appearance and the second notice of appeal or amended notice of appeal. Ms. Revenson, the appellant didn't have any attorney, not an effective one, not that required the court to do anything, because the specific holding in Shepard did not say that conflict-free attorneys don't have to follow the rules. Now, and I think that the holding in Hicks also is relevant in the sense that in Hicks, which was a civil case, obviously, Hicks versus Hicks, sorry. The time frame was not 30 days. The time frame was 10 days. It was a motion for rehearing, trying to get the order of substitution, and that was at page 304 of the opinion. And they cite to the specific rule. I think it later went to 15 days. But in any way, in 10 days, it's very difficult for somebody in prison to hire a lawyer, bring them up to speed, get everything accomplished. The Hicks court recognized that. But in addition, in Hicks, there was evidence that they attempted to comply with the rules. And as I recall, I believe they even supplemented the record later on with the proper paperwork after the fact. And the Hicks court, I think the most important aspect of that decision to say why it doesn't apply in this case is that it distinguished the Bortz case, which was from the first DCA, because in Bortz, there had been no effort to comply with the rules for substitution. They say that on page 305. Without any effort, this case, it should be controlled by Bortz and Thomas and Quail Hollow Properties. And even so, as was noted before, the sentencing court didn't rule on the motion to withdraw, didn't rule on the first motion until November, I think, like 6 weeks later, I believe it was, something along those lines.
So the court at that time had noticed that the attorney was claiming had a conflict before he ruled on the motion, correct?
Yes. Okay. There was some kind of claim to a conflict, but not in any effective.
So you're saying not in every situation that doesn't trigger an automatic
No.
Shepherd hearing?
Well, first of all,
Inquiry.
it's the same sense that the motion to withdraw a plea has to be filed before the notice of appeal. I mean, even if there's good reason to withdraw the plea, if it's after.
What do you make of original trial counsel standing before the judge and saying, I have a conflict? Not with the second motion, things of that sort. Set that to the side just a moment. If I hear Judge Boatwright correctly, the original trial counsel himself said, there's a conflict. Well, what is the trial judge to do with that? Just, well, the notice of limited appearance wasn't phrased correctly or something of that sort. I still don't, we're setting, for purpose of the argument, apparently we're setting to the side the notice of appeal just a minute. But is the trial judge permitted just to move forward when trial counsel says, I have a conflict? We just keep going?
After the plea has been entered, after a penalty.
After sentencing, after plea, 3170L is triggered? Yeah.
Yeah.
Just ignore it and move.
You move it and go on. Like I said, it's a proper issue for a 3850. And that's where this case should be resolved, in a 3850 motion.
And just so it's clear, there was no hearing held, correct, on the motion to withdraw a plea? The only order, I think, that really encompasses the motion to withdraws with an S, because I think he referenced the other one. There was not a hearing on that, is that correct?
That's my recollection. There was no hearing.
There's no requirement for him to have a hearing, correct, on that?
No.
I just want to be sure, because we're referencing that trial counsel was standing before the judge essentially saying, I have a conflict, but it was filed in the court file, it's out there, but he didn't address it before, was he aware that it had been filed? I don't know that. I didn't see that in the record. And do you think that matters?
No, I don't. No, I don't.
Okay, and you've referenced 3850 several times, and I understand the argument. Are you suggesting that we would be able to address that as the appeal stands now?
No, absolutely not. For ineffective assistance to be considered on a plenary appeal, it has to appear on the face of the record. It has to be just very, very significant.
Do you think after Dortch, we could still address that? in this fashion, in that fashion that you just referenced?
Gosh, I just read Dortch for my last appeal that I briefed, but you'll have to remind me.
Essentially saying that there is no fundamental error review, that you can't do a 3850 apparent on the face.
That's correct, yes. I'm not sure that's viable anymore. With respect to the merits of the departure issues, as far as the sentencing errors, and of course, Attorney Wilson's motion, the first motion, was found to be insufficient, legally insufficient, and I think that was a proper decision because after sentencing, it's limited to the 9.140 issues, and the only issue that would be applicable to his motion would probably be a sentencing error. But it has to be a sentencing error if preserved. Now, his motion talks about the court being bound by the score sheet. The court did consider itself bound by the score sheet in the sense that that's what the scoring, the punishment system is, in the sentencing provision is supposed to be. But, I'm sorry, I lost my train of thought.
That's okay. And if it was a sentencing error, that could have also been brought pursuant to a 3800B, even after the notice of appeal, but prior to the initial brief, correct?
Correct. And what I was getting ready to say is the 9.140, it's a sentencing error if it's preserved, and it wasn't preserved. And so therefore, I mean, when the court basically announced that it didn't see any reason for a departure, and I don't know if I made it specifically clear in my brief, but the court didn't, I don't think, misunderstood the could and should aspect under Banks. It basically said there was no evidence that supported, there was no competent substantial evidence that supported any of the grounds that were presented, which at best would have been specialized need, and of course the amenability argument, not that I'm willing to do it. That's not what amenability is in the departure sense. It is whether the treatment, specialized treatment, would be successful. And according to the psychosexual evaluation and report that the judge read and reread, he said they'd had a moderate risk of reoffending and that he was a pedophile. It didn't say anything about being able to cure him. It said he could manage his moderate risk of reoffending by depriving him of internet access, but that doesn't necessarily deprive him 100% anyway. With respect to the open plea, there's binding case law already that says an open plea is not a plea bargain for purposes of departure, so the court could not have erred in that regard. It was following binding precedent. With respect to the cooperation and remorse obviously
about the involuntary civil commitment issue that was raised.
Yes, sir.
And looking at the rule, it says the trial judge must, and it goes through there in subsection 9. And I think most of us, we're trial court judges, so we're familiar with reading this during the plea colloquy. That was not done, correct?
That was not done.
Okay, and then I think the last part of that rule says, as this admonition shall be given to all defendants in all cases. Had her motion been proper, not for the jurisdiction issues, what is your response to that?
They still haven't made any showing of prejudice. 3.172.
So is that the last subsection that you're looking at in that rule that deals with prejudice? Is that what you're relying on?
3.172, yes, sir.
Okay. And what about the Partlow case? You cite to that dealing with the prejudice issue.
Well, yes, sir.
And I think that had to do with sex offender registration, which is not part of this rule, correct? So there's a factual distinction in that case. Is that right?
There is a slight distinction, but the court, I believe the Partlow, or the Klein case, held also that civil commitment under Jimmy Rice is not a punishment. So therefore, it need not be expressed in that regard. Certainly, the rule does require it, but and that's why I cited the Warnos case. Obviously, in that case, the failure to notify of minimum and maximum punishments, the possibility of deportation, perjury charges upon false sworn statements, and trial rights that were being waived. I mean, I've never honestly, in In my days practicing criminal law, I've not seen or even heard of a plea that.
Is this offense, that these offenses that he pled to, are these offenses that would potentially subject him to involuntary civil commitment under Jimmy Rice?
Possibly. And with respect to the remorse and cooperation issues, again, I don't think those were preserved issues, but if they were, then remorse shouldn't serve as an issue for departure, especially when it wasn't raised, in light of the sense that the two other elements that are part of that, the isolated incident and an unsophisticated manner, there was no evidence supporting that. He apparently had been looking at these, I think, these pictures for over 10 years, and he was originally caught because he had uploaded a file onto the internet, which triggered a notification to the national hotline, which came back down again. So I don't know that that qualifies as unsophisticated or could qualify as unsophisticated. And with respect to cooperation, State versus Platt is binding precedent. Cooperating and confessing after you get caught is not a reason for the departure. I understand opposing counsel has argued that because the list in the rule isn't the exclusive list, that the court can consider other reasons. I would submit that that does not include the situations where you're only able to get to part of or one or two of the elements, but not all of the elements in a listed departure reason. I don't think that filters down and you can say, well, because I can only get remorse and I can't get the other two, that's good enough. I don't think that's proper. As far as the general sentence, these were 20 identical counts. The judge just didn't want to repeat 20 times the sentence, and he just ordered it one time. He made it concurrent. That's not a general sentence. A general sentence is one that covers third-degree felonies, second-degree felonies, misdemeanors.
What about the appellant's argument in regards to, I think there's an issue, there's a scrivener's error between a second-degree and a third-degree felony mentioned on the judgment. There was a mistake as to the designation. Is that something we can review if there was actually a scrivener's error based on what we've discussed here today?
Yeah, I think if there's a scrivener's error and it says something other than second-degree felony, then it probably should be corrected to make sure that's proper, because it was second-degree felonies, 20 counts of second-degree felonies. So unless the court has any other questions, I would rely on the rest of my arguments in my brief and ask you to affirm in all respects.
Okay, thank you. Ma'am, let me ask you before you get started, in regards to if your second motion is a nullity, you said, but hey, you still need to discuss the Shepard issue. So let's say you're right on that, okay? So let's say he now gets a new counsel. You're still stuck with that first motion, though, correct? I mean, there isn't going to be the issues that you've actually raised are much different than the first motion, which you've raised here on appeal. Those are done at that point, even if we were to agree with you, correct?
I disagree, Your Honor. The case law is replete with all of these pro se motions that were ruled upon without conflict-free counsel. When they are remanded, they are always remanded for the defendant to have the ability of conflict-free counsel, including the ability to amend the motion. One of the cases cited in the brief, I would have to review my notes, had that exact situation. The case was remanded. The judge did not allow the conflict-free attorney the opportunity to amend, and that was again reversed. In this case, as far as the jurisdictional issue, 3.111 and 9.140 require that an attorney not be allowed off the case, the sentencing attorney not be allowed off the case until they file a notice of appeal. In that situation, a client could never hire a new attorney to do the motion to withdraw the plea because the new attorney cannot come on until the first attorney withdraws, and the first attorney cannot withdraw until the notice of appeal is filed. It's a conflict in the rules. It is unworkable. It is unfair, and it deprives people of their Sixth Amendment right. As far as the idea that this should be resolved in a 3850, Shepard spoke on that. Shepard said, and I quote, "Deferring issues to the post-conviction process that can be effectively dealt with at an earlier point is neither efficient nor preferable." If I can move on to the Jimmy Rice issue for a second, the state cites Klein for the idea that this warning was merely collateral and therefore not prejudicial, but that's contrary to the precedent. Here in Partlow, the Florida Supreme Court held, and this is, quote, "The voluntariness of a plea depends on whether the defendant is aware of the direct consequences of the plea and those consequences listed in Florida Rule of Criminal Procedure 3.172C. At the time that the court considered Klein, this warning hadn't yet been added into 3.172C. So I would argue that the case law discussing whether the warning was essential before the rule was amended is superseded by the rule amendment. As far as the downward departure, here the attorney made an argument for downward departure for mental health treatment based upon a specialized need. He submitted and was received into evidence a psychosexual evaluation that indicated that treatment would be effective in this case, that treatment was available, effective, that the defendant was willing to participate in that treatment. That psychosexual evaluation, in conjunction with the attorney's arguments, provided the step one basis under Banks for the court to downward depart. The court failed to acknowledge that, failed to make findings on that. May I finish my sentence?
You may.
And that is error under Banks.
Go ahead.
You'd like to have one more minute. We'll give you another minute to finish.
Yeah, go ahead.
We'll let you finish your argument on that point. We took up some of your time on issues you weren't probably prepared for.
So here, there was a psychosexual evaluation admitted into evidence without objection, and that psychosexual indicated that there were positive indicators towards rehabilitation, there was a willingness to, and I'm quoting, a willingness to accept responsibility, there was a recognition that he needed treatment, there was a willingness to comply with treatment, that treatment could result in his DSM-5 conditions being managed successfully, that they could be managed with treatment, and that he had positive indicators towards rehabilitation. That allows the court the basis necessary to find that it can downward depart for a mental health condition requiring specialized treatment and a defendant that is amenable to that treatment. The court finding here that because there wasn't a negotiated plea with the state, the court only ever addressed that, and he says, nope, there's not that, so there's no basis to depart here, and that was an error. And in the Green case, the court remanded for the exact same error. The court stated in Green that the trial court erred by making no specific findings as to the availability for departure under, in that case, subsection DRI, which mandated reversal, and Green was reversed.
And counsel, if I could just, I know we're over time, I just want to address the issue you brought up with respect to a conflict. You say there's a conflict in the rules. Has this court or any other court ever addressed that or elucidated that? And you did not file that below, is that correct? You didn't indicate that as a problem below?
I indicated in my briefs that there was a conflict with 3.111 because in order for me, the only reason I filed a limited notice instead of just filing a notice and seeking substitution was because 3.111, and the rule is repeated in 9.140, the same rule, that an attorney, the sentencing attorney, cannot be withdrawn until the notice of appeal is filed. And I didn't indicate that in my briefs that is why I had to file the limited notice instead of seeking substitution.
Okay, thank you.
Thank you.
Anybody have any other questions?
I do not.
Okay, all right,
Thank
thank
you,
you,
Your
ma'am.
Honors.
Thank you.
Thank you, both of you. Very well argued. Thank you.
Yes, thank you.
We will stand at recess.